Welcome, everyone. I'm so pleased to have you in this session. My name is Andrea Popa on behalf of GRAC Committee. We're welcoming you here to our keynote presentation or conversation with Ira Kurzban today. And before we get started, I just wanted to review just a couple housekeeping things with you. So we're here today with Ira Kurzban, who's going to be talking to us about immigration in big picture and how the work that we do as international students, advisors and scholar practitioners fits in to that idea and that bigger picture of immigration in general. Just for some housekeeping, if you want to participate in the group, if you're welcome to change your name so that it represents your name, your pronouns, the institution that you represent, so that we know a little bit more about you. Please feel free to turn on your videos if you like. If you're busy working on something else, that's fine too. We would ask that you stay muted during this session. Since it's a keynote as opposed to a session, we won't be doing questions during the session like we would for some others, but if you do have some questions or comments that you would like to be addressed, please put them in chat, and to the extent that we have time at the end, we'll make sure to address those as we can. So I'm going to pass it over now to Liz Goss. Liz is the past chair for GRAC. She's worked on our team, or with our team, for years, and on our region she's served us so well. And as an immigration advisor herself and a former international student scholar advisor, she always does such a great job of connecting the dots, making us think outside the world of international student and scholar advising to bigger issues in immigration and connecting those dots. So I'm going to pass it to Liz to introduce our speaker.
Thanks, Andrea. By the way, I paid Andrea to say all of that, so
That's
just so you all know. So it gives me great pleasure to introduce Attorney Kurzban. He's a widely recognized immigration attorney, advocate, and champion of immigration law. He represents the best of what immigration lawyers can do for their clients, for the field in our country. Most of us know Attorney Kurzban because of the book, and I'm going to use a prop here. It's heavy. Kurzban's Immigration Law Sourcebook, an essential tool used by practitioners of all kinds, including students, attorneys, judges, and even members of Congress. And I suspect more than a few of you on the Zoom call also use it. Attorney Kurzban has litigated more than 50 federal court cases, all the way up to the Supreme Court, setting legal precedents in immigration law for family, employment-based immigration, and refugee law. Some of that includes, for example, the landmark case on the use of the Administrative and Procedures Act, the APA, which we have all become, unfortunately, more familiar with during the past administration, specifically concerning comment and notice. In addition, he also secured amnesty for over 200,000 farm workers under the 11th Circuit. Attorney Kurzban has served as AILA President, General Counsel, and currently serves as a long-standing member of AILA's Board of Governors. He's been recognized as one of the premier experts in the field, both on the floor of the Senate by Senator Durbin and similarly in the House of Representatives. I could go on for the entire hour, but knowing a little bit, getting to know Attorney Kurzban a little bit over the last year personally, I know he is quite humble and is probably already mad at me for saying this much. So without further ado, I am going to turn it over to Attorney Kurzban, and thank you so much for your time today. Pleasure to have you.
Well, thank you, Liz. Thank you, Andrea, and thanks to NAFSA Regional 11 for inviting me. I don't know if you know this, but Liz and I serve together as directors in an organization called Immigrants List, which tries to promote fair immigration laws, number one, and secondly, to try and get people elected who actually know something about immigration and are willing to talk with us about it. And Liz has just been terrific in doing that work and getting and hopefully getting all of you interested in the political process, because one way or another, unfortunately, I think we're in an environment where we need to press forward on important legislation. There's a bill, in fact, that was likely to be passed today or tomorrow that will have substantial provisions on changes in the EB5, the investor program. And over the last 6 months, we've seen a number of changes. So what I was going to try and do today was to, and forgive me, I have a little bit of a cold, is to kind of give a general overview of what I see has happened over the last 4 or 5 years. And let me start really with the Trump era. I have a particular view of it. I think that Stephen Miller and the people working in the Trump administration were actually trying to crash the entire immigration system. And they did it in a number of ways, and they did it actually quite successfully. And I think we're feeling a lot of that difficulty now, a lot of the problems that this administration is trying to dig themselves out of in some respects. I think they're having a difficult time. So, you know, under the Trump administration, as you know, they made presidential announcements, executive orders, presidential proclamations, all of which were oriented toward doing away, you know, having a Muslim ban in effect for 150 million Muslims from certain countries, you know, issuing executive orders about health insurance, the requirement that you need health insurance, trying to change the law regarding J's, F's, and M's with respect to the 3 and 10-year bar, and a bunch of other things. They also made regulatory changes. They changed the public charge provisions. They changed the H1B provisions. They changed the asylum provisions. And they made many administrative changes in EOIR, where they require judges to actually have a docket of you know, completing a number of cases. And to the extent where, you know, when they were completing these cases, if they didn't do them fast enough, they would have a little kind of dashboard on their desks as judges that either went to red or green, depending on how fast they were processing cases, which resulted in a lot of judges leaving, unfortunately, their positions. And then there were bureaucratic changes, and those are the ones that I think you every day are probably feeling, which are changes that have to do with not staffing enough people at immigration to actually get the work done. So as there was attrition in the Department of State, and as there was attrition in DHS, and particularly USCIS, those positions were not filled. And you know, so one of the things we're saying is where it used to take 3 or 4 months for somebody to get an interview on a marriage case, it's, you know, taking a year. It's taking a year to get employment authorization in many circumstances. And that's directly attributable, not so much to COVID as I think people think, but to the efforts really to crash this system where they just weren't hiring people, particularly in the Department of State. Many consular officers left and nobody was hired. So you had both COVID, but you also had a real attrition of people in the agencies, and therefore nothing was getting done. And indeed, today we're still feeling that. So what happened when Biden came in? The first thing he did, as you know, is issue a series of executive orders, ending the Muslim ban, ending the travel bans, although he then replaced the travel ban on South Africa when Omicron became an issue. I suppose they may do that again if we have certain problems. They made major regulatory changes. They dropped a number and settled a number of lawsuits that were filed against the Trump administration. So, for example, there's no longer a health insurance requirement. The employment and asylum regs that were submitted are not in effect, that were submitted right before Trump left office. We have a case, for example, that you may have heard about, the UNNJ, where I set up a phony university called the University of Northern New Jersey, and they got accreditation and everything else, and they were entrapping both students and those people who were acting as sponsors for them and they wound up indicting a bunch of people. We sued on behalf of the students, and we just successfully settled that case. So there's a different kind of mindset in this administration about getting rid of bad suits. They are defending in the courts now the Remain in Mexico policy, which ultimately will be decided, I think, in the Supreme Court. And, they have issued now public charge provisions, which are quite important, basically reversing the whole era of public charge regulations that the Trump administration had passed. They also have abandoned regulations and on continuances for motions to reopen and so forth. And by the way, I just want to give you an example. If you think you're not sure what's going on half of the time, it really isn't you. And I'm going to give you an example because I was confused about something. On October 8th of 2020, the Trump administration passed regulations about H1Bs. So we try to trace what happened. And this is what happened. First, there was the interim rule, which the Trump administration passed, which dramatically changed a number of things in H1Bs. Then that rule was set aside on 12/1/20 in a lawsuit, Chamber of Commerce versus DHS. But then the Trump administration, before they left office, on January 14th of 2021, reinstituted the H1B regulations, but the effective date wasn't until May. And when Biden came in January, he said any regulation that is not in effect or was passed in the last 90 days should be subject to review. And the agencies began to review those, and then the effective date of the final rule was delayed again until November of 2022. And finally, on June 23rd, 21, a district court ordered in Chamber of Commerce versus DHS to remand the matter to DOL. And then on December of this past year, the rule was withdrawn permanently. So I'm trying to write my book and trying to figure out what happened. And in the end, it's the same as it was 2 years ago. So nothing's really changed. But they went through this whole process. And there's a number of regulations that you shouldn't just accept as it being in effect, because the Biden administration may have withdrawn those regulations and you really need to find out about them. So what are the other things that they've done? The Biden administration in EOIR is now has an emergent, the electronic case filing. They finally come up to speed with most courts in the United States. Everything for any case that's filed in the last month and going forward, those cases will have to be done electronically. So all the filings are electronic and so forth. And that's called e-case. The second thing is they've issued a bunch of memorandums from ICE changing the policy about enforcement. Trump's policy was kind of a scorched earth policy, zero tolerance, which has resulted in 1.5 million people in removal proceedings, which is kind of a crazy number because we'll never get to them. It'll take years. And people who are deserving, who should be getting benefits, are going to be put back because of this huge backlog. They're trying to do away with that through memos by saying, if a person has a reasonable case, to dismiss it or continue it, we should, we, the agency, should do that. The Attorney General also vacated a number of Attorney General opinions under Trump. They vacated Castro-Tum, which was a case about when you can administratively close cases. Attorney General Sessions said you can't close them unless there's a regulation in effect that would allow you to do it, or a court settlement. They've reversed that and given the discretion back to the judges. that has a big impact, I think, on what you do, because often students, are in deportation proceedings, but they can get back into regular status if the proceeding is terminated or administratively closed. Then they can get back into status, and that's where they put it back now. They kind of put it back on the judge. They've changed the decisions on asylum, matter of AB, which did not recognize domestic violence, or what Attorney General Sessions called personal disputes, including gang membership and so forth, where somebody's threatened by gangs. They regarded those as personal disputes. Attorney General Garland vacated all of those opinions in matter of AB. And then he also vacated matter of LEA, which had to do with whether or not a family was a social group. For years, a family was considered a social group, which has a tremendous impact on asylum law. The Trump administration reversed that in matter of LEA 3 or 2. And then the Biden administration under Attorney General Garland has vacated that. They did the same thing with stipulations. In immigration law, it has always been the case that you could stipulate, sometimes the government will say, well, we're not going to give somebody asylum, but we'll give them Convention Against Torture Relief, or we'll give them withholding of removal. In the case ACAA, Attorney General Barr did away with that. That has now been restored so that government attorneys, ICE attorneys who are doing these cases can negotiate and actually settle a case, which would move things along much further, and I think get cases resolved. I think the thing that has the most impact on you, obviously, is in light of the stalling of H1B, people in the administration, I guess, came up with the idea of using STEM. And you may have seen the new STEM regulations. If you haven't, they're at 87 FR 3317. They were issued on January 21st of this year in the FR. So, and what do they say? They first of all expand the categories, as you may know, of who qualifies for STEM. They now include climate change, forestry, business, financial and data analytics, industrial and organizational psychology, social science research methodology, and quantitative methods, and a bunch of other areas. So you should take a look at that if you haven't seen that. It's quite important. And the STEM subject must be the F1 major or dual major, according to these regulations. And a student minoring in a STEM area does not qualify. And this was by guidance on April. Actually, it was older guidance in 2010. So a STEM student must be allowed 24 months extension. You know about all that, of course. And then they also started a STEM program, an internship program at 22 CFR 62.23. 22 CFR 62.23. It permits foreign students who are currently enrolled in an accredited post-secondary academic institution outside of the United States to participate in what amounts to really a J program, a new J program for STEM students. And you probably should take a look at that regulation. Also 62.23A. And then they did two other things that were quite interesting with STEM, which is they're trying to, I think, strategically allow STEM people to become residents, much easier. There are bills in Congress like the Compete Act, which would make it easy and make it crystal clear that somebody who can go from STEM to residency quite easily. But the Competes Act has not passed. And in the interim, at least, what they've done is they've said, looking at STEM and national interest waivers. And there's a provision in the that you may want to look at in the policy manual of USCIS. It's at 6 USCIS Part F, Chapter 5, D2. That's 6 USCIS Policy Manual, Part F, Chapter 5, D2. And what they've done is they've changed the criteria to make it much easier for someone who's in STEM to get the to become a resident by using NIWs. It's not a slam dunk by any means, but it's certainly trying to make it easier for them to become residents. And they've done the same thing with entrepreneurs and evidentiary considerations by making it much easier for people who are entrepreneurs under the special entrepreneurial program that we have to also become residents through the, or at least get the benefit of the parole entrepreneurial program. Okay, in addition, they did some important things with adjustment of status transfers. They've just recently said in the last month that if you have a pending I-485 application to become a resident to adjust your status and it's employment-based, you can change from one category to another. In other words, if you filed your adjustment in EB1, and there are visa numbers available in EB2, you can just file a new petition and you will get the original priority date of the adjustment that had been filed. And you can just go ahead and get your residency that way. And the same thing with EB2 and EB3. As you know, they have various backlogs for India and China. Sometimes they become more current, some are more advanced. So many times people apply for both EB2 and EB3 to get their residency. And if they do, they can now use this special adjustment provision. Now, why are they doing that? Well, one of the things that happened under the Trump administration is in order to crash the system, they just didn't adjudicate cases. So as of this year, there's 140,000 visas available, which is extraordinary. 140,000 visas available in the employment category over and above the normal allotment. So they're trying to get those used up as fast as they can by, you know, allowing people to switch from one category to another much easier. And then on the Afghan relief program, as you know, the administration started an Afghan relief program, and that program allows now, and Congress passed additional visas, now 34,500 special immigrant visas that allows spouses and children to come in. It allows people to become residents much easier by waiving some of the provisions in regard to Afghans who are coming into the United States. And the administration allocated $1.2 billion additional dollars for refugee needs, particularly for Afghan refugees. Okay, and then let me just talk briefly about what the kind of business trends are. The other part of the program, by the way, was the Operation Allies Welcome Program. And what they're doing is they're giving parole and work authorization to Afghan refugees who are coming into the United States. and trying to get people resettled as quickly as possible and on the road to lawful permanent residency under that provision. Okay, and what other, let me go over some regulatory fixes. They just issued public charge regulations, as you may know. And those public charge regulations are an effort to hark back to the original idea of what public charge was, which was not to, as the former director of USCIS said, make persons self-sufficient. That was not the purpose of the public charge provision. And to then therefore require them to have jobs and a certain amount of education and so forth. Quite the contrary, it was simply to say that they had to make a judgment that a person would not go on what we used to call welfare, or not go on a federally means-tested benefit. So their efforts now are back in that direction so that we don't have this heightened, I think, kind of crazy standard where you have to submit an affidavit and a bunch of other things to show that you have a job and education in order to come in. It was kind of and health insurance. It's kind of a backdoor way of raising the standards so that people who were poor couldn't come into the United States. I think the administration is now changing that, as long as they're not public charges. Administration also issued SIJ regulation, special immigrant juvenile regulations, just this week. And I think yesterday just issued changes in their policy manual because, under special immigrant juveniles, they only give a certain amount of visas per year. So now we have backlogs that go on 4, 5, 6 years where people have been determined to have SIJ status, but they can't get their residency because there are no visas available. The Biden administration yesterday said, or the day before said, well, what we're going to do is we're going to give everyone who already is qualified, but just hasn't been able to get their residency because of the backlog, we're going to give them deferred action, that meaning allow them to stay, and we're going to give them employment. So, you may come across students who are employment authorized by virtue and have been given deferred action by virtue of these changes last week. Okay, and then the administration is fighting court decisions. In the prior administration, everyone ran into court in the Northern District of California or the Western District of Washington or the Eastern District of New York and Brooklyn, because those are considered the 3 most liberal districts, challenging a lot of what Trump did. Well, the shoe's on the other foot now. And what's going on is the state of Texas and Oklahoma and Florida and a bunch of others are running into court in the Western District of Texas or the Northern District of Texas, because it's within the Fifth Circuit Court of Appeals, which has really become an outlier court. I mean, it is really, their decisions, to put it mildly, are bizarre and extreme. So what they've been doing is they've been going before these judges in the Western District of Texas or the Northern District of California, who are very sympathetic to the illegal alien, anti-alien message that Governor Abbott in Texas and Governor DeSantis in Florida have been mimicking. So they're trying to defend those cases right now. And to show you again how crazy this is, the Biden administration kept in effect Title 42. And Title 42, you may know, is a provision of not immigration, but a public health provision. It's 42 USC section 245. and we call it Title 42 because it's under Title 42. And what they've done is, what Trump did is he said, we're just not going to let anybody in the country because of COVID. So he used a public health measure for purposes of stopping people immigrating in the southern border. But it's very targeted. It doesn't stop people who have visas. It doesn't stop people who have border crossing cards. It doesn't stop residents or citizens or people in the military and so forth. It was targeted specifically at persons who were non-residents, non-citizens, who were coming to the border seeking asylum. And they have effectively used this policy to simply push people out of the country without giving them any hearing whatsoever, on the theory that this is a public health measure. It's not a immigration issue at all. Well, the ACLU has sued them on this, and the state of Texas has sued on it. And yet on Friday, we got two different decisions. The state of Texas sued because when Biden came in, he kept Title 42, which I think is a disgrace, as a measure of anything we are resembling a humane society, because after all, in 1967, we signed a convention, a protocol relating to the status of refugees. And the convention came out of World War II, where people were coming to the borders of Switzerland and to the trying to get into the United States or Cuba. And, you know, there's a famous story about the return of a ship from the United States and Cuba, where the people ultimately were turned away and wound up in concentration camps and died in concentration camps. But on the Swiss border, the same thing was occurring. People were trying to get out, and the Swiss said they wouldn't let people in. And so after the war, the nations of the world got together and established the United Nations Convention and later protocol relating to the status of refugees, which says we cannot expel somebody at our borders who's seeking and fleeing persecution, who's seeking shelter and fleeing persecution. So there's a provision of the convention, Article 33, that says, it's called a refoulement provision. It says we cannot send somebody back if their life or freedom would be threatened. In the Convention Against Torture, we have the same provision in Article 3. We will not send somebody back to a country where they will be tortured, period. And that's without regard to how terrible the person may be. Even if he himself was a torturer, we will not send that person back to be tortured if we believe he or she would be. So the question became whether under Title 42, you can just throw people out of the country like that. And so when Biden came in, he said, well, I'm going to carve out an exception for unaccompanied minors. So if an unaccompanied minor comes to the border, we will let them in and we will try and determine whether or not they should be given asylum or withholding of removal or Convention Against Torture relief. And the state of Texas challenged that. And on Friday, a judge in the Northern District of Texas determined that, yes, the administration carving unaccompanied minors out was arbitrary and capricious, and ordered the administration to enforce the law for everyone and to treat minors as adults and to simply invoke Title 42 and send them back. On the same day, in Washington, D.C., in the D.C. Circuit Court of Appeals, the court decided that, yes, the administration has the power to use Title 42 to exclude people, but they cannot exclude people who are seeking asylum. In other words, they have to give them the right to have an asylum application heard, or, well, not asylum, but at least having a Convention Against Torture claim heard, or what we call withholding of removal. That is, the person's life or freedom would be threatened. So under those circumstances, the DC Circuit said you cannot enforce Title 42 to prevent people who are fleeing persecution and wish to assert a claim. Not asylum, but withholding and Convention Against Torture claim. Some of the other things that the administration has done, unfortunately, have to do with kind of defending positions that the Trump administration engaged in. And why? Part of it is, from a legal point of view, the Justice Department and the Solicitor General's office like to be consistent. And one of those examples was whether or not, if you were given temporary protected status, you could adjust your status in the United States, even if you entered illegally, because TPS, temporary protected status, is a status for which you can change and become a resident. The prior administration took the position that you could not. The Biden administration defended that in the Supreme Court, and the Supreme Court decided that you cannot adjust your status and become a resident from TPS to another status if you entered illegally. The other problem is that this administration, like many others, has bought into the myth of what I call the immigration industrial complex now. Just like the military industrial complex, we now have a system that's been infected all around the United States with the financial power of the federal government developing a system that requires counties and cities and states to be supportive of, for example, incarceration. So just to give you some numbers, the ICE budget, as I understand it, according to a recent report, is $16.3 billion. When I started practicing, admittedly, it was a long time ago, they probably had, INS probably had the equivalent of $10 million at the border. And why has this occurred? It's not that so many more people have been coming. It's that they have, in effect, created this complex at the border. So I did a tweet the other day about, we now have robot dogs at the border. They have drones flying at the border. They have movable equipment to survey large areas electronically at the border. They're spending billions of dollars on all of this stuff. So ICE's budget this year, CBP's budget was 16.3 or 14.7, depending on who you believe. The ICE budget was $7.9 billion. And that made HSI the second largest investigative agency in the United States. It mandates now that we have in detention people who are incarcerated, 32,500 beds, which makes ICE the largest agency in the United States government for detaining people. So ICE now incarcerates more people than the Bureau of Prisons. They put in there $655 million for walls and fences at the border, $120 million for border technology. So, and why is this so pernicious? The issue of incarceration is pernicious because what they do is they take the money and they give it to local impoverished cities and counties and rural areas where the jail the county jail or the city jail, is now, one of the major employers. And this is the same that we do, with the military industrial complex. I mean, it's spread out all over the United States. And so we're giving money to these local counties and cities to incarcerate people at the cost of billions of dollars, when it would be much cheaper to release them, even with an ankle bracelet, if that's what you wanted to do, even with some monitoring device. And yet they keep doing this. And the GAO just this year issued a report saying that the Department of Homeland Security was giving local county and city jails $20 million more in places where no one's being detained. So what is it that they're doing? I mean, in effect, they're just buying support from these various local counties and agencies. Okay. I only have a few more minutes here, so let me talk about what we have been trying to do at Immigrants List, and Liz, I think, knows quite a bit about this. We have come up with some ideas about administrative changes in immigration, which we're trying to get passed in light of the difficulty of getting statutes passed. Early filings of adjustment of status, expanding the definition of custody and through no fault of its own. In other words, if you consider custody as something that doesn't require incarceration in a jail, you have a very different view of what's happening to people who are coming to the US. Another provision that I've tried to work on is this provision about through no fault of its own. Many of you know about this because it's a basis sometimes to have students reapply after they fall out of status if they can show it's, quote, through no fault of their own. The agency has very narrowly interpreted this, and we think it deserves a very broad interpretation. So, for example, reconsider the idea when someone is subject to malpractice by an attorney. The agency has often said, well, that's your problem. You can sue the attorney, but we can't say that's through no fault of your own. You hired the attorney. So there are things like that in terms of administrative interpretations that can become very important. And I invite all of you to think of other examples because we're trying to press the administration to come out with a regulation that defines, I think, in greater detail and is more generous than this through no fault of your own provision. We've also asked them to reconsider when someone is in a status unauthorized by the Attorney General. Right now, if you're a student and you are challenging the termination of your student status or the revocation, or you're seeking to be reinstated into student status, all of that time counts as unauthorized presence in the US. Most people don't realize this, that the more you appeal or seek a motion to reopen or something like that, it doesn't stop the running of unauthorized presence. So sometimes, as we had with the UNNJ case, the students were fighting it, and after a certain period of time, they were barred for 10 years. Because as a result of trying to be reinstated, as a result of trying to switch schools and so forth, after they were terminated, all of that time counted as unauthorized presence. So in our settlement in UNNJ, we said that they would not count any time as unauthorized presence against these students. And there's a whole bunch of other, if you file a non-frivolous application for residency, you should be in a status authorized by the Attorney General. If you're fighting removal proceedings, you should be in a status authorized by the Attorney General, and so forth. Just very briefly, in finishing up, Congress is about to pass a new EB5 bill. It was included in the House provision yesterday of the appropriations bill. As you may know, Congress has to pass an appropriations bill by Friday. So the fact that this provision was included, it's like 80 pages on EB5 new provisions. And it's the Grassley-Leahy bill that they've tried to get passed for a number of years. But it does a couple of things. One is it reauthorizes regional centers. So the regional centers are now going to go forward. Number two, it sets the amounts at 800,000 for a TEA or 1,050,000 for any other areas. So as of Friday, if it passes, and I assume it will, or Monday, instead of what we have now, which is a 500,000 investment or $1 million, it's now going up to 800,000 or 1,050,000. And it also has a number of provisions in regard to taking to task the regional centers for compliance issues. And, you know, there may be more legislation coming up. Senator Durbin and Senator Grassley just unveiled a bipartisan H1B bill, which prevents outsourcing, prevents more than 50% of an employer having H1s and Ls, gives preference to STEM students to get their residency, says their degree must be in the specialty occupation that you're seeking as an H1B, now requiring that the jobs be posted on websites so that people can get a chance to do it. And they set a wage floor for L1s. I think this bill has a good chance of passing at some point. It's not in the appropriations bill now, but you know, we are at Immigrants List, and I hope you'll look at our website where we're trying to pass legislation, as I said at the beginning, that we think is more reasonable, more favorable to immigrants, and is not just focused on border issues, but on issues of students, on issues of L1s, H1s, and on issues of fairness and deportation and detention. So that's kind of the summary. I see there's a couple of things in the chat. Let me, okay, Liz, you just put something up. If anybody has any questions or we have any time, I'm happy to answer them.
Does anybody have any questions? I put the Immigrants List website in the chat. Yeah, if anybody's interested, we're, you know, there's a lot of work that needs to be done, obviously. And I think this is a great organization focused on these things. And obviously having Ira on is the leader of this, it opens a lot of doors for conversations that sometimes we, you know, we might not have otherwise. Although he wouldn't admit that, but it's true. So.
Well, I hope I haven't bored you all. So David, you have a question?
Yes, I had a question about the case you said about TPS. Do you have just a technical question because I wanted to read the case, but do you have the site off the top of your head?
Yes, the case is Sanchez, S-A-N-C-H-E-Z, I forget. But it was in the Supreme Court this past term. So the Supreme Court decided the case last year. I don't have it offhand.
Okay, I'm sure I can look it up. That should be enough. And then, so I'm thinking about, you know, I've heard from a number of the relief organizations like HIAS and others that are helping Ukrainian refugees. And so given that case, the Biden administration's response, as I understand it, to the Ukrainian situation was to grant TPS. But given that case, is there a better, if you were advising someone, in Poland who wants to come to the United States, is there something better than taking advantage of TPS if they ultimately wanted permanent residency?
Okay, well, first, you have to be very careful. I always tell people this and they're a little bit shocked, but you have to be very careful about what you say to people who are outside of the United States, because it could be construed as alien smuggling, and they have. So in other words, like if you tell somebody, well, you can come to the border in Texas and see if you can sneak in, or I'll help you do it, or whatever, that's alien smuggling. So just keep that in mind as kind of a general background thing, but that doesn't mean you can't tell them opportunities that they would have. I think as a practical matter, unless people are here, they're not likely to get benefits at any time soon, although they can certainly apply for visas in the countries that have been designated. I think they designated Poland, and then they designated 1 or 2 other countries for immigrant visa processing. So if they had a case that was already in immigrant visa processing, they should continue with it. They can also apply, obviously, for visas, but it's going to be very difficult, non-immigrant visas, I mean, but it is going to be difficult for somebody to get, for example, a tourist visa. Maybe they can get a student visa to come in, or maybe they can get an E visa or an H visa or something like that. And somebody can apply for them here, and they can show up at at really any embassy, and they're likely to give it to them if they meet the qualifications. I don't think they're going to give out a lot of tourist visas, because they realize, there's 1.5 million people who would want to come in tomorrow. I think the options are limited. You could ask for humanitarian parole. A lot of people have asked for, but the case, I think, has to be a more particularized case. In other words, I'm dying of cancer, or I have some illness, or my child has some illness. You can always apply for humanitarian parole. And if they're here under humanitarian parole and TPS is granted, they're likely to, get TPS.
Okay, that's very helpful. Appreciate you flagging that case because I hadn't heard of it.
Yeah.
And then also providing this information, and I'll be careful. I'll be careful about not getting myself arrested.
Right.
Okay, I think Eva Swift from the University of Vermont had asked, I think you kind of addressed this already, but they'd love to hear your thoughts about what we might or might not see as far as roll-off or broader support for individuals from Ukraine and other regions affected by war.
They could, and this is, one of the things, Liz, we could talk about an immigrants list. Traditionally in the United States, we have had very broad parole programs. For example, we paroled in Indo-Chinese refugees in the 1970s. We paroled Hungarian refugees in 1956. We paroled Haitian and Cubans in the Haitian-Cuban Act at one point. So the question is, under what circumstances are we willing to have a broad parole program to allow people to come in? I think just as we're doing with Afghans, they could certainly have that program. These programs ultimately result in residency. The problem is you now have a very organized, strong opposition to the use of parole. It's based on the fact that in 1980, when Congress established the Refugee Act, they put in a provision that says parole should only be done on a case-by-case basis, because we were using parole legitimately, I think, in these kinds of situations where all of a sudden you have, this this upheaval and the war going on. And so, we can try and get something like that passed. And that's something all of you can, who are interested in the issue can certainly press for. Why don't we have a parole program for Ukrainians in the way that we've had it for Hungarians in 1956, for displaced persons in 1954, for Indo-Chinese refugees and so forth. I mean, even Cuban refugees, remember, they were all paroled in even after the Mariel refugees were paroled into the United States, even after the Refugee Act of 1980. The act was passed in March, I think, and people from Mariel came in April and May, and they paroled 120,000 people in. So we have the ability to do that. They're going to get a lot of headwind from people on the, anti-immigrant crowd who are going to say we should not parole large numbers of people in the country as a program. You can do it one by one, which is silly. But, they can do it. And they can also pass a regulation that allows them to do it. I mean, this is the issue involving, the kids who either both DAPA, right? And prior programs, DAPA was, deferred action, both DACA and DAPA, deferred action for childhood arrivals, deferred action for parental arrivals. They were both parole programs. Now, people challenge it saying, it wasn't an appropriate program and so forth, but there's no reason why they couldn't have a Ukrainian parole program to bring people into the country. So Liz, we can put that on the agenda.
We'll put that on the agenda. Well, thank you very much for your time. I think we still have the vast majority of people on, even post the presentation time. So I think that just speaks to how much everybody appreciates hearing from you. And I certainly learned a lot of things. I hadn't thought about the immigration system in terms of the industrial complex, but it makes a lot of sense. So really appreciate all the work you've done, Ira, and thanks very much for spending some time with us today.
Thanks, Liz. Thank
Bye,
you
everybody.
all for inviting me. Appreciate it. Take care. Let's see.